My brother claimed our grandmother's inheritance was already divided, then asked me to cover her nursing home debt. I replied, "Show me the paperwork." 4 days later, the estate lawyer called me stunned. The text came in at 11:23 p.m. on a Wednesday, and I remember the exact time because I was still awake grading midterm papers at my kitchen table, a cup of chamomile tea gone cold at my elbow, and my phone lit up with my brother Desmond's name in a way that made my stomach do something involuntary before I even read the words. We had not spoken in 6 weeks. Not since Nana Vivian's funeral, where he had stood at the front of the church with his wife Priscilla on his arm and received condolences as though he were the only grandchild who mattered, which was, in every way that mattered, practically, the role he had been playing for the last 3 years of our grandmother's life. The text said, "Nadia, I need you to cover Nana's outstanding nursing home balance. Sycamore Ridge sent a collections notice. I've already handled my share of the estate. Yours is still open. $14,200. Let me know when you can transfer." I read it 3 times. Then I set my phone face down on the table and looked at the stack of papers in front of me and thought very carefully about what that text was actually saying. My share of the estate. As though there had been an estate. As though something had been divided. As though I had, at some point in the process of our grandmother dying and her affairs being settled, received something that obligated me to a nursing home debt that I had never been informed existed. I turned my phone back over and typed 4 words. "Show me the paperwork." Then I went back to grading, though I didn't retain a single sentence I read for the next 40 minutes. I want to explain who Nana Vivian was, because this story is ultimately about her, and doing her justice requires more than describing what was stolen from her. Vivian Ades. Okafor Briggs was 81 years old when she died, and she was one of the sharpest, most deliberate, most self-possessed people I have ever known. She had come to the United States from Nigeria in 1972 with her husband Emmanuel, who died of a stroke in 2009 after 37 years of marriage. She had worked as a licensed practical nurse for 24 years, saved every dollar that wasn't strictly necessary for survival. And by the time she retired, she owned a 4-bedroom house outright in a suburb of Columbus, Ohio, a modest investment account, and a rental duplex on Whitfield Avenue that generated approximately $1,400 a month in income. She had not inherited any of this. She had built every piece of it through choices that looked like deprivation from the outside. The same car for 12 years, the same house without renovation for 2 decades, the same shoes resold rather than replaced. And that were, from the inside, a precisely executed strategy to leave something behind. She used to say when I was young and asked her why she didn't spend more on herself, "I am spending on myself, Nadia. I am spending on the self that comes after this one." She meant us. She meant her grandchildren. She had been building something for us our entire lives, and when she'd been meticulous about it, and I had known this and trusted it, and had, apparently, failed to pay close enough attention to what was happening in the 3 years before she died. I am a high school English teacher in Columbus, which means I am not a wealthy person, but I am not a struggling one either, and I have exactly the kind of life that Nana Vivian would have approved of. Organized, purposeful, not prone to drama. I am 34 years old. I live alone in a 2-bedroom apartment I chose specifically because the 2nd bedroom has good light, and I can use it as an office. I drive a 2018 Subaru Forester that I bought used and will drive until it becomes impractical to repair. And I have a small savings account and a retirement fund that I contribute to every month without fail because Nana Vivian explained compound interest to me when I was 13 using a legal pad and a felt tip marker, and the lesson stuck. I am, in short, the kind of person who reads documents before signing them and keeps organized files and follows up on things that don't add up. My brother Desmond is 5 years older than me and has spent most of his adult life either not being these things or performing these things so convincingly that even people who should have known better were fooled. He is handsome and socially fluent in a way that I have never been, the kind of person who can make almost anyone feel, for the duration of a conversation, that they are the most important person in the room. He had used this quality on our grandmother for years, and I had watched it happen and had told myself each time that I was being ungenerous, that his attention to her was genuine, that his weekly visits and his management of her affairs were acts of love rather than positioning. I was wrong about this for a very long time. The first sign that something was genuinely wrong came not with Desmond's text but 3 months before it, on the day Nana Vivian was moved into Sycamore Ridge Memory Care Facility in Gahanna. She had been diagnosed with vascular dementia 18 months earlier, and her decline had been, as these declines are, both gradual and sudden. Gradual in the accumulation of small changes and sudden in the moments when the accumulation became undeniable. And I had been pushing for a professional care assessment for nearly a year, calling Desmond regularly to suggest that we needed outside help evaluating Nana's needs, and he had deflected every suggestion with variations of the same reassurance. He had it handled, he was checking on her, she was fine. When she was finally admitted to Sycamore Ridge, I learned about it not from Desmond but from a voicemail left by a social worker at Riverside Methodist Hospital, named Constance Adeyemi, who had been working with our family for the previous 6 months and who called to let me know, gently and carefully, that my grandmother had been admitted to the ER after a fall and that the hospitalist team had determined she could no longer safely live alone. I called Constance back within 4 minutes and asked her why I hadn't been notified when the fall happened. She paused before answering, which told me she was choosing her words with care. She said that her contact on the family side had been primarily Desmond, who had listed himself as the emergency contact and primary family representative. She said she had flagged in her notes that there was another grandchild, me, who had called several times over the preceding months with questions about Nana's care, and that she had recommended to Desmond on 2 separate occasions that I be included in care meetings. He had told her I lived too far away to be practically involved. I lived 12 miles from our grandmother's house. My hands were cold when I put my phone down. I drove to Sycamore Ridge the same afternoon I got the call from Constance. I want to be precise about what I found when I arrived, because the details are important and because I need you to understand that what I'm describing is not a family that had a misunderstanding about paperwork. It's a family in which one person had been systematically removing another person from the picture. The facility was clean and well run, a long single-story building with manicured grounds and staff who clearly knew their residents. Nana Vivienne was in room 14, a single room with a window that faced a small courtyard garden. She was sitting in a chair by the window when I came in, and when she looked up and saw me, something moved across her face that was not confusion. It was recognition, and something that looked almost like relief. And underneath both of those things, something that I could not name then, and have spent a long time since trying to find the right word for. Grief, maybe. The particular grief of a person who has been somewhere alone for a while and had started to wonder if anyone was coming. I held her hand for a long time, and I told her I was sorry I hadn't come sooner, and she patted my hand and said my name twice, and then looked out at the courtyard and didn't say anything else. I sat with her for 2 hours. Then I went to the administrative office and introduced myself to the admissions coordinator, a woman named Beverly Tran, who had been with the facility for 8 years, and I asked to be added to all communications regarding my grandmother's care, and I asked for a copy of the admission paperwork. So Beverly pulled up the file and went through it professionally and then paused, in the same way Constance Adiemi had paused, and told me that the power of attorney on file listed Desmond Okafor as the sole legal representative for all health and financial decisions. She asked if I had a copy of the document. I told her I had never seen it. Beverly printed me a copy of the first page, which showed the document date 14 months earlier, and Nana Vivienne's signature and Desmond's name in the designated agent field, and no secondary agent. I folded it and put it in my bag. I thanked Beverly. I drove to the parking lot and sat in my car for 12 minutes before I could make myself start the engine. The next thing I did was call our family's attorney, or rather the attorney I had believed was our family's attorney, a man named Gerald Ibarra who had handled our grandfather Emmanuel's estate in 2009 and whom I had assumed was still the primary counsel for Nana Vivienne's affairs. Gerald had offices in downtown Columbus, had been in practice for 26 years, and was the kind of attorney who remembered details about your family from conversations half a decade old. He picked up on the second ring when I called, and I explained that I was Nana Vivienne's granddaughter and that I had some questions about the estate. Gerald was quiet for a moment and then said carefully that he had to be transparent with me. He was no longer Vivienne's attorney of record. He had received a letter approximately 16 months ago from a different firm, informing him that his services were no longer needed on the estate matters. He'd found it surprising, he said, because he'd had no direct communication from Vivienne herself, but the letter had been accompanied by a properly executed notice of representation change, so he'd closed the file. He asked if there was anything he could help me with in a general capacity. I asked him who the new attorney was. He told me, a firm called Noel & Associates, and the named attorney was a man named Curtis Noel. I had never heard of Curtis Noel. I wrote the name down on the back of the parking ticket from the Sycamore Ridge lot. Then I asked Gerald one more question. Had he drawn up the power of attorney that Desmond was using? He said he had not. He said that the estate documents he'd prepared in 2009 had included a standard POA naming both Desmond and me as co-agents, requiring joint signatures for major decisions. He said this very carefully, and I think he understood what he was telling me. The POA I'd just seen from Beverly Tran, the one naming Desmond alone, had been created somewhere else, by someone else, 14 months ago, without Gerald's involvement, and, I was increasingly certain, without Nana Vivienne's full understanding of what she was signing. I want to slow down here and describe the experience of understanding something terrible in stages, because I think people who haven't been through it sometimes imagine that revelations arrive whole and clear, like a photograph developing all at once. That is not how it works. What actually happens is that you get a detail, the POA, and you hold it, and it feels like one thing, an oversight maybe, a family decision you weren't included in. Then you get another detail, the changed attorney. And now the first detail has more weight. Then you get a third thing and a fourth, and at some point the weight of accumulated detail tips the balance from uncomfortable to undeniable, and the thing you've been half knowing becomes something you fully know, and the shift is not a relief. It is the least relieving feeling imaginable. Over the following 6 weeks, while visiting Nana Vivienne 3 times a week at Sycamore Ridge, and watching her decline with the specific helplessness of someone who loves a person they cannot save, I accumulated details. Yet I learned from Beverly Tran that all billing communications had been directed to Desmond, and that the facility had on file a signed instruction from the POA agent, Desmond, specifying that no financial information should be shared with any other family member. I learned from the Whitfield Avenue Duplex Property Management Company, after considerable back and forth that required me to document my identity as a family member of the owner of record, that the rental income had been redirected from Nana Vivienne's personal account to a new account approximately 19 months ago, and that the authorization for this redirection had been signed by the POA agent. I learned from the Columbus County Recorder's Office that Nana Vivienne's house, the 4-bedroom house that my grandfather had helped her purchase in 1988, the house where I had spent summers, the house whose kitchen still had the hook where Nana hung her apron, had been transferred out of her name 14 months ago into the name of an LLC called Briggs Family Holdings. I looked up Briggs Family Holdings on the Ohio Secretary of State's Business Registry. The registered agent was Desmond Emmanuel Okafor. Gone. Just like that. I did not call Desmond when I found out about the house. I want to be clear about this because the question of why I didn't confront him immediately is one I've had to answer for myself many times since. The simple answer is that I was afraid of what would happen if he knew I knew. The more complete answer is that I had, by that point, consulted with enough people to understand that the kind of documentation I needed to protect Nana Vivienne's interests and potentially recover what had been taken from her required careful assembly before anyone tipped their hand, and that calling my brother in a fury and demanding explanations would give him time to move assets, destroy records, and construct a narrative before I had anything solid enough to counter it. I had learned this from a woman named Philippa Ose, an elder law attorney in Columbus with 19 years of practice, whom I'd been referred to by Gerald Ibarra and with whom I had my first meeting in a conference room that smelled like good coffee and old books. Philippa sat across from me for 90 minutes and listened without interrupting while I laid out every detail I had. When I finished, she did not look surprised. She looked the way professionals look when a case confirms something they've been seeing patterns of for 20 years. She said, "What you're describing is a textbook elder financial abuse situation. The isolation from other family members, the consolidation of legal authority, the redirected income, the asset transfer to a controlled entity. These are the sequential steps of a premeditated financial scheme, targeting a cognitively vulnerable adult." She said the word premeditated with the same calm specificity she'd used to say the word standard, and I remember thinking that she had probably said it many times, and that the fact that it had become ordinary to her was simultaneously reassuring and devastating. She told me what we needed to do. She told me not to call Desmond. Philippa Ose referred me to her colleague Kwame Asante, a forensic accountant with 23 years of experience specializing in estate fraud and asset tracing, whose office was across town and who had, according to Philippa, an uncanny ability to follow money through corporate structures that were specifically designed to be unfollowable. I met Kwame on a Thursday morning 2 weeks after my first meeting with Philippa. He was methodical and exact, and had the quality of someone who finds genuine pleasure in complex problems, not in a smug way, but in the way of a craftsman who respects the work. He asked me for every piece of documentation I'd collected: the POA, the property transfer records, the billing instructions from Sycamore Ridge, the rental redirection documentation, the business registry information for Briggs Family Holdings, and he spread it across his desk and looked at it for a long time without speaking. Then he asked me a question I hadn't been asked before. Did I know whether Nana Vivian had a will, and if so, when it had last been updated? I told him I had always assumed she had one. She was not a person who left things unaddressed, but that I had never seen it and didn't know who held it. He said this was critical. He said that in estate fraud cases involving a cognitively declining adult, one of the most common final moves was a will amendment. He said I needed to find out whether the will had been changed, when, and by whom. He said this with a calmness that made the words feel heavier than they were. See, finding the will required a different kind of work than finding the property records, because wills aren't typically filed publicly until probate. I went back to Gerald Ibarra, who told me he had a copy of the will he'd drafted in 2011, 2 years after Emmanuel's death, in which Nana Vivian had divided her estate equally between Desmond and me, with specific bequests of personal property to each of us, and a provision that the Whitfield Avenue duplex be held in a family trust for 10 years, generating income to be split between us before it could be sold. He faxed me a copy. I held it in both hands in my car in the parking lot of his building, and looked at my name in the distribution clause, Nadia Chisholm Okafor, equal beneficiary, and felt something that was partly relief and partly fury, because this was evidence of what had always been intended and simultaneously evidence of what was being taken. I brought the copy to Philippa. She said it was useful, but that what we needed to determine was whether a subsequent will had been executed, whether Desmond had taken Nana Vivian to Curtis Noel's office and had a new will drafted that changed the distribution in his favor. Philippa filed a formal inquiry with the Ohio State Bar regarding Curtis Noel's practice and requested any estate planning documents prepared for Vivian Aday's Okafor Briggs. The inquiry was filed on a Monday afternoon. 3 days later, Curtis Noel called Philippa's office, and the conversation that followed was not the one he'd been expecting. Curtis Noel was, as it turned out, not a specialist in elder law or estate planning. He was a general practice attorney, solo practitioner, who had been in practice for 11 years, doing mostly residential real estate transactions and occasional contract work. He had no particular experience with dementia patients or capacity assessments or the specific protocols that should accompany the drafting of legal documents for cognitively impaired individuals. What he did have was a client referral from Desmond Okafor 18 months ago, and what followed from that referral was a series of documents that he had drafted and notarized over the following 6 months: the updated POA naming Desmond as sole agent, a new will that divided Nana Vivian's estate 80% to Desmond and 20% to me, and the deed transfer of the family house to Briggs Family Holdings, LLC. Noel had not administered a capacity assessment before drafting any of these documents. He had not required independent counsel for the signing party. He had not noted in his files any concerns about the client's cognitive state, despite the fact that Nana Vivian had been diagnosed with vascular dementia 4 months before the first document was signed. He had, in short, done exactly what an attorney should not do when drafting major legal documents for an elderly client whose family member is sitting in the room during every meeting, and whose dementia diagnosis is available in the medical records of every physician she'd seen in the preceding year. When Philippa laid all of this out for him in a 45-minute phone call, Curtis Noel went from defensive to very quiet to deeply cooperative in a progression that Philippa later described to me as among the fastest she had ever witnessed. He agreed to provide copies of all documents. He agreed to provide his billing records, meeting notes, and the names of anyone else present during the signing sessions. He also, Philippa told me, asked whether there was any way to keep his name out of the resulting proceedings. There was not. I should tell you where I was in all of this emotionally because I've been describing the legal architecture so precisely that I'm worried it reads like I was fine, like I was a competent professional executing a strategy without personal cost. I was not fine. For when I was visiting my grandmother 3 times a week and watching her diminish in ways that were specific and cruel, the morning she didn't remember my name, the afternoon she called me by her daughter's name, the day I arrived and she was looking at a framed photograph of Emmanuel with an expression I recognized as the specific bewilderment of a person who knows they should know something and can't reach it. I was teaching 40 students a day the mechanics of language and storytelling while carrying a secret that felt like something physical, something I could feel in my sternum when I sat at my desk. I was sleeping badly. I was eating erratically. My friend Amara Nwosu, who had known me since graduate school and who was the only person outside the legal team who knew what I was doing, he came over on a Thursday night with takeout and sat with me at my kitchen table while I went through documents, and at one point she put her hand over mine and said, "You know you're not doing this to hurt Desmond. You're doing it because it's right." I told her I knew that. I didn't fully believe it yet because I was still, underneath everything, the person who had grown up with Desmond, who had shared a grandmother, who had a decade of holidays and family dinners in my memory, alongside the evidence of what he had done. Grief does not wait for the right moment. It arrives concurrent with everything else. Nana Vivian died on a Saturday morning in October, 5 months after I first walked into her room at Sycamore Ridge. I was there. I had been there the night before. And I had gone home at 10 o'clock because Beverly Tran had said she'd call if there was any change, and Beverly had called at 6:14 a.m. I drove to the facility in the early light and sat with Nana Vivian until 8:37, when she stopped breathing. She did not wake up. She was not in pain as far as anyone could tell. Her hands were warm, and I held one of them, and I thought about what she had said to me once about the self that comes after this one, and I thought about everything she had built and everything that had been taken, and I said very quietly that I was sorry and that I was going to fix it. I don't know if she heard me. I have to believe she did. I drove home and called Philippa and told her that Nana was gone. Philippa said she was sorry, genuinely, and then she said, "This is when the estate proceedings open. This is when we move." I told her I was ready. The funeral was held the following Saturday. Desmond stood at the front and received condolences. Priscilla wore a black dress that was probably expensive. They had arranged the service without consulting me, which I only discovered when the funeral home director called to confirm the arrangements and mentioned that the family representative had approved everything. I went. I sat in the third row with Amara and my Aunt Josephine, who was Emmanuel's younger sister and who had been largely shut out of Nana's final years in the same way I had. Josephine was 73, sharp-eyed, and furious in the quiet way that very controlled people get furious, the kind of fury that doesn't raise its voice because it doesn't need to. She leaned over to me at one point during the service and said, so very quietly, she would have hated this arrangement of flowers. I almost laughed. After the service, Desmond came to find me in the reception hall and told me that he had everything handled, that the estate was being processed through Noel and Associates, and that there was a simple matter of the outstanding nursing home balance that needed to be settled before final distribution could happen. He said this smoothly, naturally, the way he said everything, as though the situation were entirely ordinary, as though I had no information that contradicted any word he was saying. I said I'd need to see the paperwork. He said he'd send it over. He never did. 6 weeks later, he sent the text at 11:23 p.m. instead. After I sent my forward reply, I called Philippa the next morning at 8:15 and told her about the text. She said, "Good. That's the opening we needed." She explained what was about to happen. Ohio law requires that a will be submitted to probate within 30 days of the testator's death. Desmond had submitted the Noel will, the 80-20 split, to the Franklin County Probate Court 10 days after the funeral. Philippa had already filed a formal will contest on my behalf, challenging the Noel will on the grounds of undue influence and lack of testamentary capacity at the time of execution. The contest cited Dr. Meredith Kowalczyk's medical records. Dr. Kowalczyk was Nana Vivian's primary care physician, with 17 years of practice and a specific documentation of the dementia diagnosis and its progression, which showed that at the time the new will was signed, Nana Vivian had been assessed as having moderate cognitive impairment, affecting her ability to understand complex financial and legal documents. The contest also cited the Gerald Ibarra will as the valid prior document expressing her true testamentary intent, and the Kwame Asante forensic accounting report, which had been finalized 3 weeks earlier, and which detailed in precise and annotated form every asset transfer, every redirected income stream, and every corporate structure that Desmond had used to remove value from the estate. The report ran to 61 pages. Kwame had a gift for clarity. Every dollar was accounted for. Every transaction was dated and sourced. The total value of assets transferred or redirected out of Nana Vivian's estate over 19 months was $892,000. $892,000. I had not known the number until Kwame told me, and when he told me I sat very still in his office and looked at the number on the page and thought about my grandmother's apron hook, about the legal pad and the felt tip marker, about the self that comes after this one. The probate contest triggered a formal investigation by the Franklin County Probate Court, which assigned a supervising magistrate named Walter Ease to oversee the proceedings. Magistrate Ease had been with the probate court for 14 years and had, according to Philippa, a specific and well-documented intolerance for estate fraud. He ordered an immediate freeze on all assets associated with Briggs Family Holdings, LLC, pending resolution of the will contest. He ordered Desmond to appear for a formal deposition within 15 days. He also referred the matter to the Franklin County Prosecutor's Office for review of potential criminal charges, citing the Kwame Asante report and the medical records as a preliminary basis for a finding of elder financial abuse under Ohio Revised Code 2913.02, theft from an elderly or disabled person, and Ohio Revised Code 1337.28, which governs the fiduciary duties of a POA agent. The referral went to an assistant prosecutor named Obiageli Nwofor, who had 11 years in the Economic Crimes Division, and who, when I met her 2 weeks after the referral, had the specific organized attention of someone who had already read the entire file and formed preliminary conclusions. She told me, in the measured language of someone who chooses words precisely because they have legal weight, that the evidence presented was among the more thoroughly documented elder abuse cases her office had reviewed, and that they would be moving forward with a criminal inquiry. I asked what that meant practically. She said it meant Desmond was going to be interviewed, and that what happened after that interview would depend substantially on whether he chose to cooperate. Desmond did not choose to cooperate. He hired a defense attorney, a man named Clifford Mensah, who had been in criminal defense practice in Columbus for 20 years, and who was good at his job in the specific way that people are good at jobs they've been doing for 2 decades in the same city. Clifford filed a motion to delay the deposition pending review of the financial documents, which Magistrate Ease denied. He filed a motion challenging the admissibility of Dr. Kowalczyk's medical records on privacy grounds, which was also denied, the court finding that the testamentary capacity of a deceased person in a will contest proceeding was a matter of legitimate public record. He attempted to reframe the asset transfers as legitimate estate planning conducted at Nana Vivian's direction, but Kwame Asante's report had been built specifically to address this argument. Every transaction was cross-referenced against Nana Vivian's documented cognitive state at the time of execution, and the pattern was consistent. The larger the transaction, the more advanced her impairment at the time of signing. Clifford was not in the end working with favorable material. What he had was a client who had been meticulous in executing a scheme and catastrophically careless in leaving a paper trail, which is the particular failure mode of people who believe they are smarter than everyone watching. The deposition took place on a Monday morning in a conference room at the probate court. I was not present. My role as a party to the will contest meant I was represented by Philippa, not attending in person, but Philippa briefed me afterward in a phone call that lasted 45 minutes. She said Desmond had been composed initially, answering questions with the fluency and apparent reasonableness that he deployed in all high-stakes social situations. He had characterized the POA and the will changes as expressions of his grandmother's genuine wishes, made at a time when she was still competent and had decided she wanted to reward the grandchild, who had been more consistently present. He had characterized the Briggs family holdings transfer as a protective measure, a way of shielding the property from potential Medicaid clawback if nursing home costs exhausted liquid assets. He had an answer for everything, and the answers were coherent and delivered without visible agitation. Then Philippa had introduced Exhibit F, the Sycamore Ridge access logs, which showed that Nana Vivian had received visitor access from Desmond on an average of 3 times a week for the 3 years before her death, and that my name had appeared in the visitor logs exactly 6 times in the 2 years before I found out she'd been admitted. 6 times, despite the fact that I had called the facility asking to visit and had been told on 2 of those occasions that Nana Vivian was not receiving visitors that day per the POA agent's instructions. Desmond had been restricting my access. It was in the records. His composure had not survived Exhibit F intact, and by the time Philippa reached Exhibit G, the phone records showing a 47-minute call between Desmond and Curtis Newell the day before Nana Vivian was taken to the Newell office to sign the updated will. The composure was entirely gone. Clifford Mensah had called for a recess 3 times in the last 30 minutes of the deposition. The criminal charges were filed 6 weeks after the deposition. Desmond was charged under Ohio Revised Code 2913.02 with 2 counts of felony theft from an elderly person, the aggregate value placing the charges at the F2 level, a second-degree felony carrying up to 8 years in prison and fines of up to $15,000. He was also charged under Ohio Revised Code 1337.28 with 1 count of breach of fiduciary duty by a POA agent, and separately with 1 count of forgery in connection with the deed transfer to Briggs Family Holdings, which Kwame Asante's report had identified as having been notarized by a notary who, based on the records, had not been present at the actual signing. A conclusion supported by a statement from the notary herself, who told investigators she had signed blank acknowledgement forms that Desmond had told her were for routine business filings. Curtis Newell, faced with a bar complaint, a civil malpractice claim, and the clear prospect of being named as a witness in criminal proceedings against his former client, had already agreed to cooperate fully with both the probate court and the prosecutor's office. His cooperation included a written statement confirming that Desmond had been present at every meeting with Nana Vivian at the Newell office, that Desmond had directed the content of each document before the meetings, and that on one occasion he had observed Desmond physically guiding Nana Vivian's hand to help her sign a page she had been unable to complete independently. Curtis Newell's cooperation did not spare him from the bar complaint. His license to practice law was suspended pending a disciplinary hearing. 4 days after I sent my text message to Desmond saying, "Show me the paperwork," 4 days after that text, I got a call at 7:58 a.m. from a number I didn't recognize. I was in my classroom before first period, writing the day's objective on the whiteboard. The number turned out to belong to a man named Edmund Joby, who identified himself as the attorney for the estate of Vivian Okafor Briggs, appointed by the probate court as successor administrator after Desmond's removal from any fiduciary role pending the criminal investigation. Edmund Joby had been in estate law for 22 years and had been appointed by Magistrate Ease specifically because of his experience with contested and potentially fraudulent estates. He did not bury the lead. He told me, in the first 90 seconds of the call, that the Newell will had been declared void by Magistrate Ease's preliminary ruling pending the full will contest hearing, that the Gerald Ibarra will was being treated as the operative document in the interim, and that as the co-equal beneficiary under the valid will, I had an immediate legal interest in the estate worth, in his preliminary estimate, approximately $1.1 million. The house, the duplex, the investment account, and the redirected rental income that was being recovered through the asset freeze on Briggs Family Holdings. He said he needed to schedule a meeting with me at my earliest availability. I told him I could come in today. He said today would be excellent. I put down my marker and looked at the whiteboard and then at the door, where my first and period students were beginning to arrive. and I took 3 long breaths the way I'd been practicing for months, and I said very quietly, to nobody in particular, "Okay, Nana. Okay." The will contest was resolved at a formal hearing before Magistrate Ease 3 months after Nana Vivian's death. I was present, seated at the plaintiff's table with Philippa Osei, in a courtroom that was smaller and less dramatic than anything on television, but that felt, to me, more significant than any room I had ever sat in. Desmond was present with Clifford Mensah, though Clifford's body language had the specific quality of a person who knows the available arguments and knows they are insufficient, which is a particular kind of professional purgatory that I almost felt sorry for him about. Almost. Magistrate Ease reviewed the evidence in a ruling that took 40 minutes to deliver, and that Philippa later told me was unusually thorough for a preliminary proceeding. He clearly wanted the record to be comprehensive. He found that Nana Vivian had lacked the testamentary capacity to execute the Noel will at the time of its signing, citing Dr. Kowalczyk's records and the specific assessment notes from the 6 months preceding the signing. He found that the circumstances of the signing, Desmond's exclusive presence, the absence of independent counsel, the failure to conduct or require a formal capacity assessment, were consistent with undue influence. He declared the Noel will void in its entirety. He certified the Gerald Ibarra will as the valid expression of testamentary intent. He ordered the dissolution of Briggs Family Holdings LLC and the transfer of all assets back to the estate. He ordered full restitution of the redirected rental income, $1,400 per month over 19 months, totaling $26,600. He referred the matter to Edmund Joby for full estate administration under the valid will. He also entered a separate finding that Desmond Emmanuel Okafor had breached his fiduciary duties as POA agent in a manner consistent with intentional financial exploitation, and transmitted this finding to the prosecutor's office as corroborating documentation for the pending criminal charges. When the ruling was complete, I looked at my hands, which were flat on the table in front of me, and they were not shaking. They had been shaking, intermittently, for the better part of 6 months. They had stopped. But I want to tell you about the nursing home debt, because that is technically what started all of this. The text at 11:23 p.m., the $14,200, the casual assumption that I owed something without knowing what or why. The Sycamore Ridge balance was real. The nursing home was owed $14,200 in unpaid invoices for the final months of Nana Vivian's care. What was also real, however, was that Desmond had collected $14,200 in rental income from the Whitfield Avenue duplex in the 10 months prior to Nana's death, money that had been redirected to the Briggs Family Holdings account rather than used to cover her care expenses, which had been what the rental income was specifically designated for in the estate plan. Edmund Joby's accounting confirmed this within the first week of his administration. The $14,200 nursing home debt was paid in full from the recovered estate assets on a Thursday afternoon. I did not pay a cent of it. I was not asked again. Desmond pleaded guilty to 1 count of felony theft from an elderly person in a plea agreement reached 5 months after the criminal charges were filed. The plea reduced the F2 charge to an F3, with a sentence of 18 months in prison, 3 years of supervised probation, and full restitution of all estate assets, approximately $892,000 in transferred or redirected value, to be paid from the proceeds of any assets he held personally, including the house he and Priscilla owned in Dublin, Ohio. Clifford Mensah had negotiated the plea well, given what he was working with, and the sentence was on the lighter end of the possible range. I was asked by the prosecutor's office whether I wanted to submit a victim impact statement. I thought about this for a long time, and then I wrote one. I did not write about anger. I wrote about my grandmother's legal pad and her felt tip marker, about compound interest in the self that comes after this one, about the specific quality of the look on her face when I walked into her room at Sycamore Ridge that first afternoon. I wrote that the harm was not primarily to me. I was 34 and employed and would be fine. The harm was to a woman who had spent 60 years building something with extraordinary care and intention, and who had spent her final years having it quietly disassembled by someone she loved. I submitted the statement. I do not know whether the judge read it. I believe she did. My share of Nana Vivian's estate, distributed to me 8 months after her death through Edmund Joby's administration, was approximately $548,000, net of legal fees and estate expenses. I want to be careful about how I describe what I did with this, because I think the temptation in stories like this is to make the financial resolution feel like a triumph, like a clean ending where money repairs the damage. It does not. What I did was the following. I paid off my car. I established a scholarship at my school for first-generation college students, funded with a gift of $75,000 and structured to generate awards annually from the interest. I put a substantial portion into a long-term investment account because Nana Vivian had explained compound interest to me when I was 13, and I had not forgotten. I kept teaching. The apartment with the good light in the second bedroom still has the same good light. These things felt right. They felt like continuity with something my grandmother had valued, which is the only version of honoring her that felt real to me. Aunt Josephine, Emmanuel's sister, called me the week the distribution was finalized. She was 73 and had not spoken to Desmond in over a year. She said she was glad that Vivian's wishes had been honored, and then she was quiet for a moment, and then she said something that I have kept, that I will keep. She always knew you were paying attention. She said so. She said Nadia is the one who will understand what I built, because she's building the same thing. I didn't say anything for a while. Then I asked Josephine what Nana had meant. Josephine said she meant that you build quietly, always and carefully, and for the future. She saw herself in you. I held that for a long time after we hung up. I am still holding it. I think I will always hold it. The last thing I want to say is about the text. The 11:23 p.m. text, the $14,200, the casual confidence that I would simply comply because I always had, because the role I had been assigned in my family's story was the compliant one, the one who showed up without asking questions, the one who could be handed a bill and a deadline and expected to reach for her wallet. Desmond had sent that text knowing what he had done, knowing what he'd taken, knowing that I didn't know, and he'd done it because he'd looked at our entire history and concluded that I was safe to exploit. He had been wrong. He had been wrong about who I was, what I knew, what I would do. He had been wrong about Philippa Osei and Kwame Asante and Edmund Joby and Magistrate Eze. He had been wrong about Curtis Noel's willingness to protect him. He had been wrong about the Sycamore Ridge visitor logs and the rental redirection records and the notary who had signed blank forms. He had been wrong about everything. But most of all, and most essentially, he had been wrong about our grandmother. He had looked at Viviana Day's Okafor Briggs and seen an opportunity in what she actually was, what she had always been, was a woman who built things that lasted, who understood that what you protect now determines who you protect later, who raised 2 grandchildren and loved them both and asked in her will that they be treated equally. He had tried to rewrite her. The law had declined. And I had made sure the law had what it needed to decline clearly, completely, and on the record. Show me the paperwork I had written. 4 words. 4 days later, the estate lawyer had called, and everything Nana had built for the self that came after hers was exactly where she had always intended it to be.